take the risk and take that stand?
We're the armed attorneys. All eyes are on the Kyle Rittenhouse case, and everyone is speculating what the outcome is going to be and what the defense case looks like. At the time that we're filming, we haven't had an opportunity to review the defense case just yet, but it raises an important question that I know that a lot of gun owners ask whenever they think about, having to defend themselves, defend their families, defend their property. And what happens if I go to trial, and should I testify? And that's the question that we want to talk about today. We got this question from the folks over on Reddit, and essentially we want to talk about kind of the pros and cons of whether you should testify in a self-defense case. But before we get started, show your support for the Second Amendment by hitting that like button. And Emily, why don't you kick off our discussion and talk about, you're a criminal defense attorney. What do you tell your clients about whether they should testify generally?
Yeah, the general defense attorney wisdom is don't put your client on the stand. And, we're talking about, self-defense cases are a minuscule percentage of all cases that go to trial. We're talking about drug cases, DWIs, all sorts of things. And generally speaking, you don't want your client to be subjected to cross-examination. You don't want them to maybe have small inconsistencies, which are totally normal and natural, in their statement drawn out to make them look like liars. It is safer to not put them on the stand, but self-defense is a little different.
Yeah, and the important thing about self-defense cases is establishing that defense itself. And in most states, it requires the production of some evidence. Some states we have legal presumptions, some states we don't have legal presumptions. But at the end of the day, the court wants to have something to rely on in order to provide it to the jury. It would be improper if there was no evidence of a self-defense case to give a self-defense instruction. And so most of the time, that has to be produced by the defense. And it's most often needed to establish reasonableness or reasonable fear. Now, I have a feeling that we probably disagree about this, but let's talk about the Kyle Rittenhouse case just a little bit. And again, we're at a time when we haven't seen whether or not he has taken the stand. But what would you say in this case based on what you've seen, Emily?
Yeah, I personally think that, and of course, I'm not his defense attorney. I am not privy to the ins and outs of all of the defense evidence of the case. But it seems to me like if I were his attorney, I would recommend he take the stand. The reason being is that, particularly for that first shot fired, he needs to establish fear. And that really comes from Kyle Rittenhouse himself. Frankly, it doesn't hurt. He's young. He looks young. Getting him up on the stand, I think, is going to remind the jury of his youth, perhaps get, a little sympathy out of the jury, especially when this very young man is talking about how terrified he was in those moments. I'd put him on the stand.
And I disagree. And this is why we get paid the big bucks, right? At the end of the day, I'm kind of a disciple of the Larry Posner School of Cross-Examination chapter in storytelling. And so I think that we could establish the story, Kyle Rittenhouse's, thought process, how he was feeling, why he acted the way he did, based on other sources of evidence, other testimony, other physical, other demonstrative evidence, video evidence. And so this is where we have the reasonable minds can disagree, and that's why it's so important. The decision to testify at trial is a really, really important right. It's so important. The United States Supreme Court has said that the defendant alone is the person who decides whether or not they testify, and it's important to talk. Say you find yourself in this situation. Don't rely on the YouTube people telling you telling you what you should do. Talk to your attorney. Your attorney is going to advise you what's right based on your particular circumstances.
And, I think that we should mention, as much as I think if I would like to see Kyle Rittenhouse take the stand, I think it would be good for his case. His case is unusual in that there are so many witnesses.
Good point.
There's video footage. Those things do decrease the likelihood that the defendant does have to take the stand because we can establish the facts, establish maybe a little bit of that fear without him having to take the stand. And I'll tell you, taking the stand is not easy. Most attorneys do not ever take the stand. I have taken the stand because Richard here one time during a trial called me to the stand to testify about something that was not terribly material to the case, but it was terrifying. I was up there 10 minutes maybe.
Maybe.
Some of the scariest 10 minutes of my life. So it's not an easy decision, but I stand firm.
Well, we hope you enjoyed this content. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
Please continue to question and comment below. And until next time, we're the Armed Attorneys.